Welcome back, everyone. This is Politics Today live on Channels Television. The Chief Justice of Nigeria, Chairman of the National Judiciary Council, Justice Tanko Muhammad, has summoned the Chief Judges of Rivers, Kebbi, Cross River, Anambra, Jigawa, and Imo States to an emergency meeting. This is part of efforts to stem the recent wave of embarrassing and conflicting ex-parte orders emanating from judges in their jurisdictions. In a letter of invitation dated 30th of August 2021, the CJN summoned the head of the concerned court to the emergency meeting to brief him on the incessant granting of the conflicting orders on suits instituted by different political parties before the various courts. Channel Television also gathered that the meeting between the CJN and the heads of the courts concerned is a prelude to a larger NJC meeting likely to hold next week. The leadership of the judiciary is said to be embarrassed by the recent developments, and the meeting is part of measures to stem the tide and to be seized of the facts before the larger council deliberation. Let's get some legal opinion now. I'm being joined by senior lawyer, Mr. G.T. Ogunye, who joins us from our Lagos studio. Thank you so much, Mr. Ogunye, for your time tonight. For our viewers who are wondering, I mean, we've reported to you stories. For example, let me take the very closest and the recent one. In PDP, there was a court order in Rivers State stopping Mr. Uche Secondus from parading himself as the national chairman of the PDP. There was a counter order from Benin Kebbi to counter the order from Port Harcourt. And a few days later, there was another court order from Calabar in Cross River State, again, stopping Mr. Secondus from parading himself. There are different court orders. What it brings sometimes is confusion. I mean, these are ex-parte orders, which we understand that for the state, it has a lifespan. For the federal, it has perhaps a double lifespan for it to lapse. And this usually happens when a party in a matter presents himself in front of the judge without even the other party present, pending the hearing of the case. So let's discuss and find out why are these confusing court orders keep cropping up in our judiciary. Mr. Ogunye, give us a sense. I know we've had this conversation before, but not specifically on this. It was something that you mentioned on the show when we were together in Lagos. Give me a sense of why this happens. Is it peculiar to politicians?
Well, thanks for inviting me. I think it happens because largely politicians think that the judicial forum or arena is an extension of their partisan platform for supremacy tussle. So for them, they want to use the judiciary, regardless of how hallowed the judicial forum is, to lawyers and non-lawyers, to strengthen their own positions in their unending political contentions and conflicts. So they don't think that that forum is too sacrosanct for them to invade and then do whatever they like. Now, my grouse is with the judiciary, and I'm saying this with all sense of responsibility. As it is said in my own part of the world, a torrential flood, a roaring flood, will not refrain from demolishing the tenement of a man who has a choice property. It's the owner of the property that will prevent that disaster from occurring. So the judiciary has a duty to rebuff politicians when they come with their deleterious briefs and cases and say, no, go away. Now, I know that there are two considerations here. One consideration is that a judicial officer, once a matter is presented, once he has jurisdiction, he is not expected to start moving out of the four corners of that case to start looking at what is going on outside. So in a way, there's a little play of the ostrich here. So you are not supposed to be influenced by other things and all that. But I have always maintained that in the law administration, law, justice dispensation neighborhood, a judicial officer is expected to know what is going on all over the place. Now, this is not the first time this will be happening. It's been happening for a long time. In 2016, for example, you will recall, there was this same problem of conflicting order between the order given by Honorable Justice Okonabang of the Federal High Court in Abuja and the order given by Port Harcourt Federal High Court headed by Honorable Justice Ibrahim Watila, then. And it's centered on the leadership tussle of the PDP then. And so what we are witnessing is a reenactment of history, and it will continue to happen. So what the CJN has done as the chairman of the NJC and what the NJC may do is salutary, because whereas other people may say, no, that's a kind of interference, allow those things to play out, and then ultimately they may then get to the Supreme Court and whatever. No, I've always maintained that the NJC, under paragraph 21, subparagraph B, subparagraph 1 of part 1 of the 3rd schedule to the Constitution, has broad powers over policy, administration of the judiciary, and to exercise disciplinary control and powers over all judges. So the petition laying protocol and the complaint submission protocol of the NJC cannot be relied upon when a state of emergency in the judiciary like this occurs to say, let's wait, let the parties complain to us. When they complain to us, we may then sanction the judges. No, before you get around doing that, the castle, the house may collapse on our heads. So apprehend that and then take the steps that you have reported is being taken right now, and then let's see how the NJC can then intervene. So that's the right step to take. I salute that.
Great. Okay, great. So let's look at it from 2 angles, and these are things that I'm able to pick out from this matter. The issue of jurisdiction and the issue of technicalities involved in what lawyers are doing on behalf of politicians. And do you call it firm shopping, where they go from one court or the other to get orders, if that's what you call it? But let's look at it first and foremost. Is it a moral issue or a legal offense for a lawyer to get out of jurisdiction to get an order?
A straightforward answer. Some of the problem we have are caused by our legislations. And I can reference Section 31 of the Electoral Act, for example, and Section 85 of the same Electoral Act. Both provisions govern submission of the list of candidates and the affidavits, and then on nomination of candidates. Now, on Section 31, subsection 5, it says that if any person has a problem, has any reasonable ground to complain about the submission of list of candidates and the affidavit they submit, that person may file an action to challenge that in a high court of a state, in a federal high court, or in the high court of the Federal Capital Territory. Meaning that there is no streamlining. So anybody can go to any high court of any state. Section 85, subsection 9, says that if the nomination of a candidate is submitted and you disagree with that there's a problem with that, you are an aspirant, you can also approach any high court of a state, any federal high court, or any high court of the Federal Capital Territory. That's how it is worded. So if you look at those provisions, you agree with me that it's possible that while you are talking about the same course of action, depending on how lawyers, bring the name of the parties, whether INEC will be the first party or whatever, or the first defender and all that, you can go to any state and file an action. And that's what is being done right now. So in a sense, you may say that, yes, the provisions of the law allow the exercise of jurisdiction by this court. But the point I'm making is that what we are seeing essentially, when you are having courts of coordinate or concurrent jurisdiction, exercising powers over the same course of action, what you have is a quintessential, it is a classical abuse of court process and forum shopping. And it borders on ethical infractions, even by the lawyers who are taking these cases.
What is the punishment
parties
for forum shopping, Mr. Ogunye? Because I know is, like you said, is on the issue of ethics and part of the ethos
I regard
of
it,
the legal profession.
I regard
what is the punishment for any lawyer that is found doing such?
There's a professional punishment for that, depending on what you call it, whether it's an infamous conduct or an act of misconduct by lawyers. You know, the Legal Practitioner Disciplinary Committee, properly convened, should be able to intervene and sanction such lawyers. Unfortunately, many of the lawyers who lead this forum shopping and, you know, take these cases around are also very senior lawyers. So in a way, they are inoculated, if you ask me, because of the principalities and powers in the legal profession. Indeed, some of the people who are orchestrating these are not only politicians, they also have their leg well stamped in the legal profession as either body of benchers, people like benchers, and so on and so forth. So the whole thing is confusing. But I think that the NJC can rise to the occasion and then deal with it decisively and say, no, not under our watch will we allow this kind of desecration of judicial processes to continue any longer. And I think that unless the NJC does that, and unless the NBA and Legal Practitioner Disciplinary Committee apprehend this and say, no, this cannot continue, the judiciary is going to be made a laughing stock, and this must stop. I think that the practice will continue because politicians place a high premium on this. It's not only the PDP that is doing this now. The last time you recall, it also happened in APC. If you want to remove somebody who's in office, you go and get an order of injunction against him. Whereas, properly considered, an order of injunction, particularly an ex parte injunction, affecting a matter that is very urgent, is to restrain something that is there to happen. How do you restrain somebody who's in an office from functioning? So it's become an act of using the judiciary to commit what I would call a judicial coup against certain political opponents. Use the order of court to remove somebody who is an officer of a party or to prevent him from acting. That's not how you use the order of court. So there are a number of issues involved, including jurisprudential question pertaining to whether indeed you can use order of injunction in that way. Don't forget, just recently, Adam Oshimole was said to have obtained an order of court, final order of court now, nullifying his purported suspension from his ward, which was indeed the foundation that was latched onto by partisans, and they invaded the court, and they were getting orders and all that. So, in this crime, all these politicians, regardless of their political party or hue or color, they are complicit. And I think that what the judiciary need to do is to step back and say, no, we won't allow you to destroy our courts the way you are destroying your parties, and that this is not going to continue any longer. I think that that's the attitude the judiciary must maintain regarding this egregious misbehavior. Yeah.
Mr. Ogunye, I sincerely appreciate the insight and the thought that you've shared on this matter. As much as the judiciary is a place where everybody run to for cover, it must also be respected so it's not bastardized and misused. Thank you so much, sincerely, Mr. Ogunye, for the thought that you've shared on that matter.
Yes, my pleasure.
But that's how we end it tonight on the program. Many thanks, everyone, for watching. I'm Sean Kimale. Bye-bye.